Hello, everyone. Welcome to The Reason We Learn. I'm your host, Deb Philman. At The Reason We Learn, we aspire to be part of the solution. The purpose of this show is to take a good, honest, potentially painful look at the way kids are being educated. We know we can do better, and this is where we'll talk about how. Let's learn something. Hello, everyone. Welcome to The Reason We Learn. I'm so glad you're here. This is a very important conversation I'm about to have. I have Ron Coleman with me here today. He's a partner at the Dhillon Law Group and resident of New York. And he's a commercial litigator with extensive first seat trial and appellate experience who focuses on primarily civil rights, unfair competition, consumer law, things like that. But he's my go-to guy when I want to ask questions about the state of the practice of law in America if I want an opinion that isn't woke. There are other people who could give it, but none as good as Ron. So I've invited him here to talk about the state of the justice system and the practice of law in general, because I'm very concerned. We've already seen what's happened in education. And, you know, in the intro, I talk about how kids are being educated. Well, that includes the kids going to law school and even the people educating them. So that all falls under the same umbrella. So we're going to have a chat today about where we are in terms of practice of law, in particular civil rights law, and what Ron thinks we should be thinking about and doing about it. So without further ado, if you're not already subscribed, by the way, please subscribe to the channel. Please like and share this broadcast as well so other people interested in the topic can get in on it. But please help me in welcoming Ron to the stage.
Hi,
hello there.
How are you? Good to see you again, Deb.
You too. So as I said, you're my go-to guy. I've been, I kind of use X, Twitter, whatever you want to call it, as my, well, it's not the only thing I use for research, but it is a big thing that I use for research. And so I've created I guess you would call it a bookmark list of stuff that I call justice in crisis. And if I scroll through this, I see a lot of students, law students, including a Harvard Law Review editor, right? Now, some of these go back into 2023 fall, et cetera. But I see students at graduation. This guy assaulted a Jewish student. This is a law student at Columbia. What's going on?
That top one is from Northwestern, which is where I went to law school.
Right. My dad taught at Northwestern back in the early 60s. And he actually was a professor. He was David Boy's professor, if you can believe that. There's a little story behind that. We'll have to chat sometime. But one wife went to become somebody else's wife. Let's put it that way. But in any case, this just goes on and on. Now, this, I think, is in England. But same idea, where we've got law students, law school graduations. That's another video of the law student playing dress up. Even you've got the American Bar Association saying they're considering a new rule requiring law schools to have free expression policies. Well, I thought they had those. I mean, it seems kind of weird. They need to codify this further. And why now? I don't feel like this is helping. This is going to help the students not protesting. And so on. So this just goes on and on and on. And my question is, rather than diving into any of these individual stories, off the top of your head, should we be worried?
Well,
future lawyers who think civil disobedience is legal, meaning like no consequences. I can shut things down and it's fine.
There are a lot of things going on here. I mean, first of all, when people make every moment in everyone's lives, not only their lives, but other people's lives, an opportunity for political commentary and gross political commentary and political theater, there's a real unhinging of sensibilities and priorities and norms that in and of itself, it's more than an aesthetically unpleasant experience. It is a rejection of decency and of civil discourse. That's the broadest conception, what we also see here is, yes, people are being graduated from law schools, top law schools. I could use scare quotes, I suppose, but I don't think it's better at less selective law schools. I would assume, in fact, it's probably even worse. People who are presumed to be the best qualified law school graduates in the country, demonstrating either an extraordinary amount of callousness towards moral truth, right and wrong, a phenomenal failure to adequately utilize analogy, which is one of the most consistently applied tools in legal education and legal reasoning, or both. And this is tolerated by schools. Will it be tolerated by the judiciary? Well, we have a member of the United States Supreme Court who would not answer the question of whether or not she could identify what a woman is. We're in trouble. Yeah, we're in a lot of trouble.
Right. And do you think this is coming from the law schools, or it's being reinforced within the law schools, or are the students arriving at law school having already been indoctrinated in this sort of postmodernist way of everything is relative and I don't need to use proper analogies, right and wrong, whatever I say? Are they getting there that way, or do we already have law professors who are reinforcing it and teaching us some new version of law that we've never seen before?
Well, I haven't been in law school since 1988. So I can't tell you what is really happening, but I think your second hypothesis is the one. They are showing up with what the old Professor Kingsfield called a head full of mush, and they're leaving with a head full of mush. That's the difference. That was one of the points that I just tried to make, is they don't seem to have been affected by legal education. Even if they are able to analogize and think dialectically, they are turning off that part of what should be their educational training, because they see that in today's world, that's what gets action. That's what gets results. That's what gets a nation, or rather, that's what gets recognition by nations as appropriate responses to hard issues. And Northwestern has been particularly awful, and I won't call it Pritzker. My school, they renamed it a few years ago because one of the Pritzker family gave them a huge donation. I think that's abominable when you have a school that's already well established and wealthy. But Northwestern in general has been terrible in terms of dealing with campus outrages, and the law school had to have known that this kind of acting out would take place at graduation. And there are hundreds of people. I mean, unless they've increased the law school size significantly, when I was there, it was 200 per class. The vast majority of whom just want to get their diploma. Yes, they're lawyers. They should be involved in world events. They should be engaged in right and wrong. Yes, they should have something to say. But that doesn't mean that one of the things that we lawyers are supposed to be good at is channeling dissent into appropriate formats and appropriate forums, and displays of pro-terrorism feelings are disgusting in the first place, but they're also a negation, again, of that lawyerly sensibility. People keep referring on social media to, well, these people are making themselves unemployable. And yes, it's true that some New York firms and some other large firms have said, well, we're not going to hire people that we learn have been involved in these kinds of things. These people were probably, yes, maybe some of them were going to these major firms, but there is a lot of money out there to hire these people in NGOs, many of which are being funded either directly by the United States government or your state government, or indirectly in phony baloney collusive settlements where private corporate money is being used as part of the settlement and being sent to these radical NGOs. These people are not too concerned about being accepted by the establishment. And I had a discussion, I keep invoking this, with David Latt, the conservative founder of Above the Law, with which he is no longer involved at all, thank God. I said, David, do you think this is going to, it was a couple of years ago, it didn't have to do with this particular issue, but it had to do with these sort of radical conduct by law students. And he said, well, ultimately you're going to get to court and you have to be able to defend your argument. You have to really be able to comprehend your adversary's point of view. And one of the problems we see with this generation is that they can't even comprehend, they can't grok the other point of view. It is utterly null to them. And he said, well, that won't work in court. Well, now that we have a Supreme Court justice who is prepared to say that you have to be a biologist to identify a woman,
mm-hmm.
and now that we have seen the sort of multi-ring circuses that are happening in Georgia and New York and the District of Columbia District Court, where legal norms and standards and constitutional standards have been just utterly jettisoned for a political purpose, it's getting really hard to wonder what the backstop is going to be.
They're changing language too. I believe it was Chicago. They changed criminal to something like to justice system impacted
justice impacted persons.
So something like you can't even
utterly
say.
Unbelievable. And I'll tell you, I actually I was shown the video from that last night by Mrs. Coleman, the renowned writer for Legal Insurrection. And it was justice impacted individual.
Justice impacted individual.
And do I have screen sharing authority here?
You should. It should be you see down at the bottom.
No. I use this all the time. I just want to see if I okay. So let me show you what Jane tweeted.
Sure.
If I may. I think you'll get a kick out of it. So this is the original video that you're talking about.
Right.
When we do that,
Illinois just right.
Over and over again, we keep changing the names for how we are referring to those who are have.
Oh, my mouse drives me crazy.
Criminal activity, and each time.
Hey, Officer Krupke, corrupt you. I mean, they were joking about this. They were joking about this. I want to stop sharing. Stop screen.
Okay.
They were joking about this in the 50s. But it just keeps coming back. But now, and even in the Officer Krupke song in West Side Story, they were making fun of the distortion of language,
Right.
social disease, and I'm depraved because I'm deprived, and all that stuff. But one thing we consistently see, and James Lindsay's always talking about this, they changed language. They changed language to obfuscate reality.
Mm-hmm.
And as much reason as there is to be pessimistic and concerned.
Right.
On the other hand, I still think that there is no system in our society that is better equipped to address the evisceration of meaning than the adversarial justice system. And it's true that judges can badly distort this and have done that and will continue to do that. But as long as there's some oxygen still in the system, we still do have the ability to confront people with bad evidence. Again, if your name is Trump, you don't even get that. And eventually that's going to have to be resolved. But yeah, there's lots of reason to be concerned. And these law school, well, I mean, one of the other interesting things about the legal profession, which you know from your experience and your father's experience as an academic, is that it's uniquely tied to the academic world. In a way, I mean, some doctors stay involved in university hospitals, most don't.
Right.
But the legal profession, I think, is more tied to the law schools than, we're hiring out of the law schools. There's just this, even people who've been out of school for decades are often still reckoned in the pecking order based to some extent on where they went to law school.
And also who they know who's teaching there.
Who they knew,
So,
who taught there or who's
right.
teaching there now, right? Yeah.
Right.
What were you going to say?
Well, I was going to say that not only are you correct in terms of, I can hear a little echo, by the way, but I would
it's, you know what, there's some crazy construction project. I'm going to lower, because I don't think it's an echo. I think you're hearing, they're doing some kind of pounding all day long here.
Okay. I thought I was hearing my own voice, but in any event, my dad always taught in law school throughout his career. So, I mean, he would take small breaks, like when he was working for the government of Israel and he was traveling all the time, he couldn't, but he remained a professor. He, early before I was born, he taught at Northwestern. He also taught at NYU. He taught at Yeshiva. He taught at a bunch of different places, and even UConn. And so he remained in it, as you're saying, and involved. He taught courtroom advocacy and tort and things of that nature. But when he was interviewing as a partner in a large firm, he was also keeping himself apprised of who was teaching at the various law schools who were sending candidates to interview. He would look into their background, their philosophy, what they'd written for their law reviews. He had to read what they'd written. If he didn't know what they were saying in the law review of that school, then he felt he couldn't effectively evaluate the candidates that they were recommending. And likewise, he would look at the course choices for the candidates, and if he saw too many something studies and or they had never taken contracts or whatever, like they'd skipped something important or skipped something that they thought might be boring, but instead they took like LGBT studies and law, whatever. And he would ask them, why did you do that? And he expected to get some substantive answer. But
how recently
well,
is this experience that you're describing?
He
now?
left, so he passed 2 years ago. I think is it 2 years ago now? But he left the practice of law in, I would say, 1993 or 4 or something like that. And then he became just an adjunct professor at UConn, and he was teaching constitutional legal history. mostly to undergrads at that point. But prior to that, he'd always been involved in teaching and hiring. And before it split up, and he was one of the first to leave, he was a partner at Finley Cumble.
Oh.
Yeah. And
in New York?
In New York, yes. And
So
yeah.
At 425 Park Avenue.
Yes, sir. And he left when they hired Harvey Meyerson.
Oh, really?
He advised Steve Cumble not to hire Harvey Meyerson. He said, please don't do this. And he said, well, he'll bring in big clients and I want him here. And my dad said, this is a giant mistake. And they had a disagreement that resulted in my father saying, I will be cashing out now because I don't see this ending well. And he was one of the very few who left a creditor, not a debtor. So it may be the only one, I'm not sure. I think he's mentioned in the book very briefly as a person who had criticized.
Shark Tank, you mean?
Yeah, I think my dad's mentioned in there like in one sentence or something, but yeah. And like I said, during the Gore Bush whole flap of the election, he got phone calls like crazy because David Boies was representing Gore and because he was his professor. And there was some stuff about that. There's a whole narrative about, I got kicked out of Northwestern and had to go to Yale. That doesn't happen. But anyway, so, he was involved in this, but to your point about being involved in the academic side, he never wasn't. I don't think it was just him. If you're a partner in one of the bigger firms, you're going to be interviewing these finalists. They're going to come through your office. And he, at least in particular, because of his academic background, that was his task. You're the guy in the firm who's making sure that these people are properly educated, not just have straight A's from Harvard or Yale. It was a big pro-Yale firm because Steve Cumble had gone to Yale. So, my dad had gone to Harvard. So it was a little bit of a friction there, but he made a point of it. He said, we always had to hire one Yalie to keep Steve happy. But my dad tried to make sure that it was at least a good cocktail party Yalie, and they weren't going to that's what they were mostly good for. That's what he told me. And he said, they were good for networking. They're good for a lot of things, but you didn't really necessarily want them in the courtroom all that much. But he was happier with like Fordham. I mean,
Yale was not known for graduating practical lawyers.
Right.
He
was hiring people from Fordham. He was hiring people from NYU. He was hiring Cardoza. He was hiring people from there to be, junior associates and things because he felt like they were more on the ball. But it always came back to evaluating their coursework, their professors, what they had written for the law review. They certainly didn't interview anybody who hadn't been on the law review. That wasn't happening. So he absolutely flipped his wig when they made Obama president of the law review. I'd seen my dad angry at various points in history that he told me at the time. And I'm pretty young at that point. Okay. And he told me, he said, this is the beginning of the end of Harvard Law School. That's what he said. He said, because his reasoning was.
You're talking about when Obama was in law school?
When he was in law school.
How did he know anything about Obama?
He simply knew that he wasn't writing anything. That they made him president of the law review without having written anything. That's all he needed to know. So he didn't know Obama, any politician, anything. He just kept up with his law school, to your point about staying in the academic world and knowing what's going on there. And of course, he got all his updates. And he said, this is unconscionable he was on the Harvard Law Review. He said it was a rule, it's the top X percentage of the class. That's it. And no, he said, I understand that the presidency of the law review is a little bit of political position, but you can't do it without having written for the law review. And he was just aghast that they would make this appointment and choose somebody who had not himself produced. And he said, this is a sign. This is a very bad omen. And of course he was right.
And Harvard has always been a leader in legal education. They going back to, the 1800s, people look to Harvard to see what things are being done. But also, Harvard produces faculty. Yale also. And these people then promulgate the sensibility. And look, and who taught them? Larry Tribe taught them. Dershowitz taught them. Dershowitz is not particularly good at expressing regret. He has changed many positions about many things in his life, but full-throated regret for the extent to which he played a significant role in sending a generation of American lawyers and the legal profession into this abyss. That I haven't heard, but I don't know that anyone would care, I suppose, that anymore. Anyway, but where does this leave us? I mean, it's not just the legal system. No. Besides the fact that the legal system is huge, because when we see that people who thought they'd never have anything to do with the legal system, yes, we know that in minority communities, people find themselves interfacing with the legal system in ways that middle class and upper middle class and wealthy people typically don't. But now we've seen through the January 6th experience and through the weaponization of the justice system throughout American society, that's bad enough. But the other point is that lawyers are embedded throughout virtually every institution in America, and where they're not actually making decisions, they're sitting at the side of people who are making decisions. And one thing your father, I think, would also agree, especially having spent time with Finley Cumble, is that there is the people who do best and who go the highest in the legal profession, whether it's in private practice or government, are those who are the most risk averse and the most, at least, I want to say deferential, but they might not actually be deferential. They might actually be subversive, but the most deferential seeming to power, which is why I haven't ever gone very far in the legal profession. But these are the people who are of, the GCs and the corporations advising companies or signing off on companies discriminating and establishing programs that are unconstitutional, that are illegal under the civil rights laws. But they're not really doing legal analysis. They're assessing, which is part of their jobs, but they're assessing the overall likelihood of getting away with it.
Right. Exactly.
And telling management, whose inclinations are not toward doing what's right, but towards maximizing, you thought I was going to say shareholder value. I didn't know. Maximizing their economic benefit. Mm-hmm. And if that happens in the short term to benefit shareholders, that's great. So we've got, and this goes through government agencies, it goes through corporations, it goes through education. Every one of these schools that are in the teeth of judicial decisions prohibiting them from doing this, going around parents to transition children and to expose children to pornography and all this stuff that's coming out now, that's going on in the schools. Lawyers are signing off on this. And one possible reason for optimism, again, another stream of oxygen that comes into the system, is the plaintiff's bar. Mm-hmm. First, on the one hand, you have, in terms of the campus stuff, firms are starting to take on pro bono, major firms like Greenberg Traurig, taking on these schools representing students who have been victims of discrimination. And then you have the many nonprofits that are operating out there that are challenging these things in the courts. And you have plaintiffs, I don't want to be unduly idealistic sounding with regard to either side of this. The plaintiff's bar, pro bono aside, is motivated by profit. But
Right.
because of that motivation, they are beginning to see success in bringing cases to hold hospitals and institutions, whether it's schools or universities and other and corporations, responsible for denying people medication, for COVID, unapproved medication, or not scientifically unapproved, but politically unapproved.
Sure.
For unlawful discrimination or so-called reverse discrimination. The profit motive is beneficial this way. So hopefully listen, one of the most important things that's going to happen in the next 12 to 18 months, in my opinion, is that there will be another Supreme Court justice appointed by the President of the United States. I don't know. I wish that the older justices, such as Justice Thomas in particular, remain hale and healthy for a very long time to come. But it seems inconceivable to me that in the next term, the next presidential term, that there won't be another Supreme Court justice named. And if Democrats have the White House and the Senate, or even one of those, it's really, really going to be a problem, because we can live with one or two lunatics on the Supreme Court. And it's also possible that Justice Jackson, the one who, of course, could not say whether, she knew what a woman was, it's possible that she will mature and that she will become a better judge and move away from her ideological positions. That is really possible.
Sotomayor has been surprisingly not awful. in some cases.
You're right. In some cases she hasn't been, but she was terrible in that listening to her oral argument on the immunity case.
Oh yeah, absolutely.
It was so juvenile. It was, but
well, they definitely have it they have TDS big time. So we're right up.
So yeah, listen, there are a lot of moving parts here. You do, we haven't even talked about bar associations.
No, and even the bar exam, because there's been talk about changing that, and then even the LSAT. I'm now hearing that some law schools are not requiring students to take it, and I'm kind of
Well, the LSAT is like the SAT, a way of this finding out, especially in an era of high grade inflation and affirmative action.
Correct.
Who has the what's the word again? Aptitude to succeed in law school.
Well, it's also primarily a test of scenarios and understanding, like, to your point, do you understand analogy, and do you think logically? Can you think logically? The LSAT primarily, I think, taps into that part of the thinking, and I don't see why you wouldn't, even as a student. Are you going to be successful at law school? Are you going to be successful at the law if you wouldn't be able to pass that test? I don't think you would, in my opinion.
Well, pass. No, you can't fail.
I didn't say you have to have a high score. If you can't take it and pass it, like get a score that is remotely respectable, you probably shouldn't go to law school.
But everyone knows that minority group scores are lower on standardized tests, and there may very well be structural reasons for that. I don't really know the truth about racial distribution of IQ or test taking ability. I'm not an authority on that. But the reason schools are abandoning the SAT and the LSAT is because they want to be able to avoid liability for discrimination on in affirmative action, because they know that if someone can demonstrate that the average Black student score is X points lower than the average white student score, then just as discrimination against Blacks and against women or whatever minority it may be has been demonstrated by the use of statistics like that, it can be demonstrated in the affirmative action setting as well. The schools are riding on a sort of a pillow, especially the better schools, of equity, of trust, of reputation, where they believe, and this is not just on this topic, people who've heard me before talking about it in the context of entertainment, in the context of news organizations. Mm-hmm. Look what Disney's doing. Look what CBS has done.
Right.
We're so good, we're so well respected that we can afford to derogate our standards, because the standards don't matter. We'll just keep stamping Disney on it, stamping Harvard on it, stamping CBS on it. Right. And people will continue to be customers. What Disney is finding is that they won't continue to be customers. What the legacy media are finding is that people won't continue to be customers.
Right.
The next step then is to attack competition. I'm not a gigantic fan of Fox. I don't think the quality is particularly high. But after years and years of demonizing Fox, the mainstream media shifted its attention to OAN a couple of years ago, and other independent outlets.
Sure.
It's a little bit interesting to think how that would work in the legal world, because there are independent law schools now that are, politically independent, that are becoming known as places. George Mason is the most obvious example, becoming known as places where conservative students are choosing to go. There's so going back to the bar associations, the ABA accredits law schools. Just to be clear, you know this, but many people watching this don't. There are states that have what are called unitary bars, meaning that you need to be a member of the state bar association. It's just an administrative thing, really. You need to be a member of the state bar association in order to practice law. And that state bar association also administers the legal profession. Other states, such as New York and New Jersey, where I'm admitted, do not have a so-called unitary bar. The New York State Bar Association is merely an interest group. It's a trade association. Same with the New Jersey State Bar Association. The courts administer the legal profession themselves. But the American Bar Association in particular is even less, because there can't be a unitary bar, because there's no such thing as a federal bar. To be admitted to practice law in any federal court, you must be admitted to practice law in some state. So,
but then you have the ABA who are accrediting the law schools.
Right. So law, law schools, I mean, I'm really just riffing you said it off the top of your head at the very beginning, and this is the first time actually really that I'm thinking that I'm talking off the top of my head, because everything else we've talked about is stuff I've been thinking and talking about for a while. The legal profession is so deeply entrenched in tradition and prestige that I don't think there's a risk to the elite from people starting new law schools in the way you can start an OAN or a Newsmax. But again, when you have schools that have existed for decades or generations that begin to become centers of a sort of opposition, the only way that works is if hiring institutions such as law firms are interested in hiring from those schools. So for George Mason, I think it's working. We're seeing pushback from judges. So also people should understand that the judicial clerkship system is a very, very substantial power brokerage in the legal profession. Judges, particularly federal judges and particularly appellate federal judges, interview students at the top law schools. I don't care what you think the top law schools are. What matters is what these judges think the top law schools are. Usually it's the schools where they went or the schools where their colleagues also, they want, everybody wants the editor of the Harvard Law Review as a clerk. These students are presumed to be able to do legal writing and analysis on a high level and to assist the judge in writing opinions, often in areas where the judge himself or herself has little or no practical experience or professional experience. So a very good law school brain, and also a lot of the people who are on the bench are dummies. So you get someone who has demonstrated a high degree of skill, and that will then be someone who is made law review by virtue of academic performance. And ideally, as you were giving the example of Barack Obama before, has been elected by his peers to be the president or the editor-in-chief of that school's law review. Usually demonstrating some high level of legal analysis and writing and originality by publishing scholarly student work. There are a good number of Republican judges in office, and you would think that they would be a large source of support for this shift, but they mostly aren't.
That's how entrenched the tradition goes.
Yeah, first of all, they are as interested in prestige as anyone else. Not all, but most. Also, they become usually socialized by rubbing shoulders with liberal judges and the press that covers them and the clusters of power and influence around them to soften their stances or to generally be more conservative on the bench, but to be unsympathetic to parties that are too far over the line. So this is what happened on J 6th, that so many judges that were, I mean, the District of Columbia's district has never been known as a conservative court, but there have been judges that are more conservative and that have been relatively stalwart.
Right.
But when it came to J6, it just became such a highly politicized environment that they all fell into line, and they all fell into line on COVID challenges, including constitutional challenges.
Right.
The Supreme Court exercises a certain amount of pushback on that, but again, that's why that Supreme Court majority is so critical.
Right.
It's a dicey situation out there. And let me just make it really clear. The vast majority of judges in the vast majority of cases, in my 35 years of experience, really want to do their job right. They really do. Most cases are not political, and most judges are not looking at politics. We hear about the most notorious political decisions.
Sure.
And political judges. We want it to stay that way as much as possible.
Sure.
But as Marxians wish it to be,
right,
everything in our society in the year 2024, just about everything has been politicized.
Right. And I mean, if you have also in terms of local, judges, let's say family court, things like that, a lot of parents watching may run into cases, whether it's because of divorce and child custody, especially when you're dealing with some of this trans stuff, drives families apart. Judges' bias has a huge amount to do with it. And I mean, that's an extreme case. I just remember in my own case, having a judge who was an elected Democrat, I'd been a stay-at-home mom and homeschooler. And when it came to the decision, that was the status quo for a decade. And it was a mutual decision. It wasn't like I insisted on it. It was, as a couple, we had decided that. And I'd set aside during my, best earning years, set aside that. And when it came to figuring out what we're going to do during that year-long separation that North Carolina still has, the Democrat elected judge looked at me and told me to put my kids in school and get a job. And her argument was, and first of all, I was going to get a job. That's a given. But she looked at me and she says, "You have a master's degree. Why are you at home?" So, I mean, her bias came screaming through and she had no compunction. Status quo went out the window. What was best for my children wasn't even on the table. It was just, you have a master's degree. And then I got a speech about how she's been a career mom and a working mom and her kids just fine. And I'm thinking to myself the whole time I'm sitting there, is this a polemic or are you actually adjudicating here? Like what I'm getting a lecture about how I'm like a traitor to my sex.
This is a really important point. It's, we hear mostly about the federal judges, but there's been a real spate of really, really junky state court judges. Forget about the Trump cases. Lower than, something that people don't understand. In New York, the Supreme Court is the trial court. People always say it's the lowest court. It's not the lowest court. It's the trial court. Mm-hmm. It's not the lowest court. The reason it's called the Supreme Court in New York is because it's a court of general jurisdiction, and there's no ceiling to the cases in terms of monetary value or plenary power that the Supreme Court at the trial level has. But below that in New York are all kinds of, there's the traffic court, the family court, and all kinds, well, they're a family part in New York. But the point is, below the trial court level, Supreme Court in New York, Superior Court in New Jersey, there are municipal court judges and probate judges who have been abusing their office. That's as old as long as there have been judges, there's been abuse of office. But going back to the bar associations again, bar associations in most states are preposterously woke. Mm-hmm. All the administrators are female, just like in the universities. Mm-hmm. And there's always this gigantic emphasis on featuring women, professionals, and yada, yada, yada. I mean, as long as I've been in the profession.
That's right.
Women have been prominent partners in law firms. It's just a total It's a total racket.
Yep.
These bar associations become channels for putting people into, diversity.
Yep.
And you have really, really incompetent diversity appointment in important lower level courts that are really corroding the justice system. And yes, and they make these seemingly trivial decisions about the non-headline grabbing cases. But as you just described, Deb, these are the life and death of a family type cases that really affect people's lives.
And I just remember thinking, even my attorney at the time was just slack-jawed. Like, she didn't even know how to, she says, I have no recourse. I don't even know what to say to that. There's not a legal argument that's going to overcome that. The judge has no compunction, is sitting there, an elected judge, sitting there and basically projecting her own bias. His attorney was female as well. There were about two female attorneys, female judge. And there's me. And there was no question in my mind. The bias was against me because I was doing something atypical, homeschooling. Well, and she even said, I'm opposed. She flat out said, I am opposed to homeschooling. It's like, oh, okay, well, I guess I got no argument then. What am I supposed to do?
She is a monarch. She's a monarch.
And she had all the power in the world. It was just like, it's over. Boom, slam the gavel, get out of my courtroom, do what I say.
You promised we were going to talk about that video about the Senate hearing.
Yes.
Let's get that in, because flipping back up to the top of the judicial food chain, here's someone trying to slide into that system, and wow.
Absolutely. Let me grab it because I have this in here. Okay, so this is going to be Ted Cruz, who is basically grilling her. Hold on, let me grab it. Okay, so here he is, and I'm just going to go ahead and play it.
What matters more? The rights of individuals or your political ideology?
I apply the law to the facts.
I asked a question, which matters more?
My political ideology doesn't matter at all.
Okay, so I don't believe you. And I think this case demonstrates that you are willing to subjugate the rights of individuals to satisfy your political ideology. This case involves a male defendant who raped a 9-year-old boy. Was he guilty of that?
Yes, Petitioner pled guilty to that.
Okay, so he raped a 9-year-old boy. He also raped a 17-year-old girl. Was he guilty of that?
He pled guilty. The petitioner pled guilty to that crime as well.
So was he guilty?
I hope so, because she pled guilty to it.
I'm going to stop right there I want to make 2 quick points. This judge insists on referring to this person as the petitioner because they're talking about this petition to get in the female prison, as opposed to the defendant, the convicted person, or even just the person. So I got to keep driving home to you that this person is petitioning and asking the court for something, and then switches from he to she without even blinking.
He was a he when he did this.
That's correct.
1 year after being released again, he was convicted of having child pornography. Is that correct?
I'm unclear on exactly the time frame that you're at, but the petitioner was convicted of distributing child pornography.
Child pornography that was images of adults violently raping children.
Abhorrent conduct.
Okay.
For which there are real victims.
And this individual, 6'2", biologically a man. A minute ago, you said that when this man decided that he was a she, you said this individual was, quote, I wrote it down, sober and entirely a female. That phrase struck me as remarkable. Did this individual have male genitalia?
I think what I said, or at least what
that is a verbatim quote, entirely a female.
Sorry, what I meant to say was hormonally a female.
Okay, but that's not entirely. Did this individual have male genitalia?
Yes.
So you took a 6'2" serial rapist, serial child rapist with male genitalia, and he said, I'd like to be in a women's prison. And your answer was, that sounds great to me. Let me ask you something. The other women in that prison, do they have any rights?
Is that a question?
Yes, the other women in that prison, do they have any rights?
Of course.
Do they have the right not to have a 6'2" man who is a repeat serial rapist put in as their cellmate?
Senator Cruz, I considered the facts presented to me and I reached a decision.
I asked you,
Do you want to say anything about that before we go on?
It is so phenomenally, I mean, look, the facts. Well,
These are the facts. It's a man and a serial rapist. That's what the pertinent facts as far as I'm concerned. What other facts for the petitioner? I'm going to continue here.
do they have a right not to have a 6'2" man who is a serial rapist put in as their cellmate? Do those women have a right to that?
Every person who's incarcerated has the right to be safe in their space.
But you didn't think so. You didn't think so. And in fact, I'm going to give some quotes from your order because Senator Kennedy is right. This is not a judge's order. This is a political activist. By the way, the beginning of your order says, at birth, people are typically assigned a gender. I got to say that would astonish a lot of Americans. A lot of Americans think you go to the hospital, a baby's born, and congratulations, you have a little boy, a little girl. The assigned a gender, I know you went to Brown, but it sounds like it's in a college faculty lounge with no bearing on reality. The Bureau of Prison argued what I'm saying right now, that if you put this person in a female prison, there will be a risk of sexual assault to the women. And you know what you did? You said you didn't care about the women. Have you dealt in what universe is someone who is a serial repeat child rapist not at a risk of reoffending?
Senator, as I do in every case.
She just refuses to answer the question. And he does say to her, it's come up where he says, I know you have to repeat the things, whatever, but anything you want to say so far, or do you want me to go to the end?
No, I mean,
it's extraordinary. It's
It really is.
extraordinary.
It's really so. He does such a good job. It's worth going to the end.
Yeah. All right.
Because if anyone watching this hasn't seen this clip, let them at least see the whole.
Absolutely. All right. We'll go to the end.
I know you've been told to repeat the line, I follow the law. I asked a question. In what universe is someone who is a serial repeat child rapist not at risk of reoffending?
Sir, I looked at the facts that were before me in this case. All of the evidence, including the statements of every warden who had supervised this petition.
I have to say, if I were the father of one of those women, and you decided that my daughter's cellmate was going to be a 6'2" man who over and over and over again committed violent sexual assault, I would say the entire justice system is absurd, and it is clear on your record, your political ideology matters a heck of a lot more than the rights of those women that you endangered. I think you're a radical, and I think you have no business being a judge.
And I concur. I don't dispute that. I can't even fathom the woman who will end up having to share a cell with a serial rapist. And I don't care how many hormones you put into this person. We just know it also sets all kinds of precedent, and we're going to erase the existence.
But you know what?
Difference.
She was also questioned by Senator Kennedy.
Yeah.
And she observes that for people who are not familiar with the situation, she's a United States magistrate judge. A magistrate judge is a judicial officer who is not appointed by the President of the United States and does not have to be confirmed by the Senate, does not serve for life, deals with sort of directing traffic in the courts, helps out the district judge or district judges with certain preliminary things. They issue a lot of warrants. It is a stepping stone in some cases to being nominated to be an Article III judge. But when they issue certain kinds of rulings, they are called reports and recommendations. The report and recommendation is often just rubber stamped by the judge, but the point is that the Article 3 judge, but the Article 3 judge is the one who has the ultimate responsibility for ruling. They will often farm out decisions to magistrate judges in order to not have to work sometimes, or sometimes there are certain categories of decisions that are sent to the magistrates. So this woman, Netburn is her name, Judge Netburn, Magistrate Judge Netburn, is a magistrate. She has been nominated to the federal bench as by Joe Biden. And that's why we're talking about her report and recommendation. So she's going to point out to Judge Kennedy that her report and recommendation was adopted by the court, and apparently there was no appeal by the government. So she's only part of the problem, but it's worth listening to him too.
Yeah, listen to one quick thing. I think what I would have said if I'd come to me, if I were on the Senate Judiciary Committee, I'd say, are you a woman? And I just watch her say, well, yes. How do you know? It's like, how do you know? I want to hear her say I was assigned female at birth or some other nonsense, or I feel like a woman or something. Just to say it out loud, get it on the record.
McLean, also known as July Justine Shelby.
Yes, I know who you're referring to.
Okay. Mr. McLean raped a child, didn't he?
30 years ago, the petitioner in the habeas case before me,
Did he rape a child?
he pled guilty to that crime. Yes, it's before
And
me.
then he raped a 17, he raped a little boy, right?
I believe that's correct. I believe he pled guilty to 2 acts of sexual violence.
And then he raped a 17-year-old girl, right?
Again, this case was handled by the state court in Indiana, but I
I'm just
believe
asking you the facts.
I believe-
Don't stall on me now. Did he rape a 17-year-old girl or not after raping a 9-year-old boy?
I believe that's what he pled guilty to.
Okay, and then he went to prison, didn't he?
Yes.
Ron, her answers are strange to me. I understand how, if you're nominated, you want to get confirmed, but she would do better in terms of her own credibility to simply yes, no, that's correct. But she frames everything in a way, to my ear, that is trying to cast this individual in the best possible light. He pled guilty. It's irrelevant. He did it.
Exactly. And I was surprised that Kennedy didn't go back to that, because she kept saying that he pled guilty. And what you could ask her is, do you have any reason to believe he was not guilty?
Right. Why would you call it out or tell us this? Like, why is it relevant to, he asked you a yes or no question, how he got there or how he got to be convicted is really not relevant. Did he do it? Yes or no? And the answer is yes, if he was adjudicated guilty, whether it was pled out or not. And she's like, she has to keep saying it over and over. And then she has to toss in, an abhorrent crime. But I keep hearing a but. Like, it was really bad, but he pled guilty is what I'm hearing. It's a very strange framing. And I don't know if she was coached to do that. Like, this is going to make
it's not only, Deb, it's not only a strange framing. If someone tried that in the witness stand in a case where she was presiding, she would ream that witness. Answer the question.
Right. Yes or no.
Answer the question that was asked. But you know what?
But they get away with this whenever every time I see a hearing and they ask yes or no questions, they're coached to go in there and give their narrative. And I think that, both Kennedy and Cruz have done a good job in terms of getting back on track. But I'm just, as a member of the public I'm watching this and I'm saying what she conveys to me, not only that she's an activist, but that, as they've pointed out, she's quite committed. You don't go, I don't care how much coaching you have, you don't go out there and cling to that framing unless you believe it yourself, unless on some level you believe this guy deserves a break. I'm not just an administrator, I'm actually making the world a better place or some kind of thing. There's something about her that is committed to this.
And then he came out and he sent child porn.
I love the way he talks.
to adults, right?
Child porn.
And he was sent back to prison, right?
The petitioner pled guilty to
Was
one.
he sent back to prison?
Well, that case was in the federal system. So
Was he sent back to prison?
yes, this time to federal prison.
Thank you. And then he decided to transition. And he became a female. He started going by July Justine Shelby. Is that right?
Yes.
And Miss Shelby said, I don't want to go to a male prison. I want to go to a female prison.
You know what I would also like to have asked? I would have looked into it. I had one of my pages look into it. Has this individual been assaulted in prison while incarcerated by other men? Because we know that people guilty of child rape and any kind of activity of that nature tend to be persona non grata in prison. And so it could very well be a cynical move to, I don't want to get my butt kicked anymore and risk getting shivved by people who don't like people like me. I'm going to pretend to be a woman.
Yeah, although that might tend to make him sound somewhat sympathetic as a victim.
Well, that's true, but it would also, I mean, I think you'd have to ask it a certain way, but the point is, if they knew that there's a potential that this is all fraud, in other words, that this isn't really, not that there is such a thing as really a woman, but what I'm saying is there's no reason whatsoever to be sympathetic to this person. And if this goes forward and becomes more of a thing that we just look the other way, we're going to have all kinds of pedophiles in female prisons, because if they go to male prison, they're going to get beat up.
Yeah, no, that's a good point.
That's all I'm saying is, like, I can, if he were just a bank robber, would we be having this conversation?
But so, all right, and now look where she goes. It's really amazing.
And the Board of Prisons said, what planet did you parachute in from? You're going to a male prison with this kind of record. And you sent him to a female prison, didn't you? You said that the Board of Prisons was trying to violate Ms. Shelby, former Mr. McLean's constitutional rights, didn't you?
I issued a report and recommendation to the district judge recommending that the district judge transfer the petitioner to a women's facility. The district judge
You said
adopted
that
that
the Board of
recommendation.
Prisons was trying to violate Ms. Shelby's, Mr. McLean's constitutional rights, didn't you?
So I based my decision on the facts that were presented to me in the record.
But it wasn't that your ruling?
I recommended finding that under Estelle versus
Why
Gamble.
won't you admit that was your ruling? Are you ashamed of it?
I'm not. I'm answering the question. I applied Estelle versus
But
Gamble.
was that your ruling?
My recommendation was that the petitioner's serious medical needs were being denied by keeping her in a men's facility.
A violation of the Eighth Amendment, right?
That's correct.
Okay. And how big was Ms. Shelby, Mr. McLean?
I don't have a specific recollection. Your colleague just suggested that she was more than 6 feet tall.
And you told the Board of Prisons, well, she'll be okay. The other women in the female prison will be okay because it's only hypothetical that Ms. Shelby, Mr. McLean would reoffend again after he's already raped a 9-year-old boy and a 17-year-old girl and has been sending child porn through the mail. You said there's no chance he'll reoffend again. Did you say that?
Senator Kennedy, I based my decision on the record.
But am I right? Did you conclude that?
I don't have a specific recollection of that. I did recommend that after finding a constitutional violation.
What were you thinking in saying it's only hypothetical that she would reoffend?
The facts of the case were that.
Stop it here for a second. This is amazing. And again, it's always easy to second guess. It's only hypothetical. the entire process of determining where a prisoner should serve is premised on not the entire, but one of the components of many determinations made by judges is danger to the community, risk of being attacked. Of course, it's hypothetical.
Yeah, prison isn't just for punishment. It's to remove you from society.
Right. So, but hypothetical includes things that are 90% likely to happen in the future.
Right.
But listen to what she says about, she uses a term called a contact offense.
Engaged in a contact offense 30 years ago, the petitioner had not engaged in any contact offense. In addition, the medical evidence made clear that for the last 5 years, the petitioner was sober and hormonally entirely a female, and there was no.
What? I'm sorry, entirely a female here. What does hormone? So am I no longer entirely a female hormonally because I'm postmenopausal? Like what does that even flipping mean? There's no specific hormonal profile that makes you entirely a female. If he still has his junk, I'm sorry to be graphic, but you'd have to start with getting rid of that for starters. You'd have to. Just have to. But I mean, this is absolutely obscene to me because, correct me if I'm wrong, I'm not an attorney. You get to the Eighth Amendment, you talk about constitutional rights. It completely invalidates the existence of a male and female difference to say that a man can take a bunch of pills and become entirely a female. Then there's really nothing to protect women from. Any man is as good as anyone. I mean, there's no difference. It's a chemical profile at that point. I can't wrap my brain around how the law squares that. Same with Title IX when they changed it. My brain cramps and just breaks when you tell me that a law that is there to protect females of the species equally applies to males of the species who say that they're female. So we're now going to protect women from men who say they're women, but not really, because they're just the same as women. Sorry, this is where I get dumb. How's that work? Legally?
Legally? I mean,
we just rewriting this stuff on the fly now?
Well, no, I mean, I'm sure that she was, I didn't read her opinion, but she's accepting the premise that this person has transitioned to becoming a woman and therefore is a woman and hasn't attacked anyone for many years. Actually, of all the things she says, this is perhaps the most compelling. That, you know, we do know that the recidivism rate among pedophiles is extremely high. If he hasn't attacked anyone for many years,
he's been in a male prison. He's been in a male prison, and his profile, while I know that offenders are not strict to profile, he had a 9-year-old boy and a 17-year-old girl, so he seems to go whatever, smaller than he was. Let's say, can we say smaller? That his tastes tend to run to at least smaller.
And he's 6 feet 2 inches.
He's 6 foot 2 inches tall, but a lot of male prisoners.
Of people in that women's prison.
Correct. And so, I mean, he hasn't had a contact violation, but he's also been in a place where they're just intrinsically hostile to his profile of crime. And for all we know, he's been under separate, special guard because of that, because they do tend to take pains to keep those people away from Gen Pop a little bit because they know what's going to happen. And so he may not have even had a chance, but you put him in a woman's prison and the whole thing changes. And I just don't see why you would take that chance. First of all, what's many years? And they say like 9 years, 5 years. I don't know how many years, but to me, regardless, it's all predicated on the notion that a man can say, I'm now a woman. I've taken my hormones for 5 years and now I want to go in a woman's prison.
Well, look, there are lots and lots of those cases. But
Yeah.
here you have someone who has a record of being a rapist
Right.
and who is a large person.
Yeah. I mean, maybe
And
if it's like a nonviolent, like I said, it's a bank robber or it's a, too many
a bank
traffic
robber
tickets,
is not, yeah, let's say a
drug
financial,
dealer. I don't.
right. Anyway, I mean, this is the kind of people that they want to put on the federal bench, and she just might not get affirmed, but you can be sure that she will not get. Let's stick a pin in this. Let's come back to it. She will get more than 40 Democratic votes.
For sure. Yeah, absolutely. And that's, I mean, I've thought for a long while, like that's starting to be the reason to vote at this point. Like, I don't see a lot of movement in either direction on other things. But if you care about how these cases end up getting decided, cases that set precedent for decades, 100 years, then it really becomes very, very important who is making these choices. It's not a guarantee. They can make terrible choices and they can choose someone who changes while they're sitting on the bench. We've seen that too. But if you're looking at your odds if Biden gets to make another nominee are really bad. And, like I said, he's with just his own executive authority changed Title IX. And that's a concern. And that's something, I just to round out the program, because I do cover education and I'm seeing all of this. So we've talked about at the top, the law schools, how that all works, the bar associations and all these things. But then you've had visibility into some of the cases where teachers who've been, wrongfully terminated, students who've had their, freedom of speech and their other civil rights violated. How's that going? I mean, are you finding that more people are starting to realize that they can't go up the food chain within the school system and within the administration, and they have to go straight to somebody like you? Or have they not figured it out yet?
Increasingly, it's necessary to get lawyers involved, and judges have been, I think, slightly more helpful than not helpful.
Okay.
But only slightly. You had in the Fourth Circuit I guess it was last month, a case where they decided that parents didn't have standing to challenge a don't tell your parents rule in a Virginia district.
Wow.
And I think it was because the parents involved had not themselves actually been affected by it. And the dissent said, you're missing the point. It is already a violation of the parents' presumptive right recognized by the U.S. Supreme Court to be involved in these decisions and for the responsibility of their children's education. Parents shouldn't have to wait until their children are ruined by one of these weirdo guidance counselors or a librarian, which seems to be the trend.
Right.
And the Supreme Court, what happened, I think, actually this month was that the Supreme Court denied cert, probably because the standing issue was a little bit complicated.
Mm-hmm.
But that's a crime. There's an important issue here.
Yeah. Do you think it would be worthwhile for people at the state level, where most of the education law around their schools is, decided or set, so to speak, like how the school is going to function with regard to parents? Do you think it'd be worthwhile for people to push their lawmakers to go back to the drawing board with in loco parentis?
Well,
and
let's
that?
not even get that. That I think is a real big stretch. It's a great question, Deb, but I think people do need to take a very hard look at what is going on in the states. Blue states legislatures are out of control and they don't get the kind of coverage that Congress does.
Right.
New York State is considering a constitutional amendment that is basically going to, if it's passed, and it probably won't pass because they skipped a procedural step,
Right.
but they want to enshrine DEI into the New York State Constitution.
Mm-hmm.
And
Mm-hmm.
the cities basically control the legislatures of the states. And in loco parentis, listen, there is a strong argument that there are lots of parents out there who are useless anyway. Let's not kid ourselves.
They
But
tend to not be the ones having their kids trans, ironically. Have you noticed that? It's not the parent who's checked out completely and has, 4 kids by 5 different, you know what I mean? It's usually the child of parents who maybe bought into a little bit of this stuff, but they didn't think this was going to happen. Right. And they wake up one day and their son is their daughter or whatever. I actually know somebody in New York that it happened to. And this is not a person who's a bad parent or a negligent parent. This is a very involved parent, but just takes this sort of like, I'm very supportive of my public school, I trust them completely kind of approach. And the kid's a little on the spectrum. And, this is very common with kids on the spectrum, kids, whatever. And so I wouldn't say always, but disproportionately seems to be happening. Either parents who like it, so they're not complaining, so they have no problem. The ones who are complaining tend to not be those negligent parents. They tend to be parents who are actually would like to be rather involved, and they've been kind of kept at arm's length. And so what I find is because you're not wrong. There are a lot of negligent parents, but I feel like I have to defend my peeps because what's happening is the good parents are getting lumped in with the lousy ones. A lot of really aggressive violations are happening to children of the good parents, the involved parents, and to them too. They're being targeted, doxxed, all kinds of terrible things. And it always comes back around to, well, but because there's bad parents. I'm like, you're not wrong, but can we stay here for a moment with the good parents? Because we can't make law around the worst examples, and treat all parents as abusive and all parents as negligent, where I thought we should be, still recognizing the separation between the state and the family. And if a parent is not doing their job, I mean, it's not the state's job to come in until you have proof. Like you have probable cause, send in DSS, do your thing. But they're mandatory reporters. When I find time and time again is when I bring up in loco parentis, I get this argument, and I'm not saying you are, I'm saying other people give me this argument. And I say, okay, you're a mandatory reporter. If you have evidence that somebody is negligent or abusive, report it. This doesn't automatically, your suspicions or your lumping all parents doesn't give you license to reparent the kid. You don't get to treat all the kids like they have no parents. And this is where the lines are getting blurred. Is there truly nothing? I know that state legislatures are absolute crap. We have 70th anniversary Brown v. Board. Look at this. Somebody put together a whole thread. You probably saw it about California and what they're trying to do with their Department of Education. And they've approved a policy stating that they believe that student benefits when district staff reflects the racial, ethnic, linguistic, and cultural diversity. And they've actually started to codify. They're getting into it gradually, but it's in there. Specifically hiring, like we're going to discriminate and we're going to segregate the staff in the classrooms and we're going to segregate the schools.
And they know that it's against federal law. They know
That's right. They know it and they're doing it anyway. And so, I guess I keep thinking like, we have the 10th Amendment. We have not all the states, but if you're still in a purplish, reddish state, like, is there a way that we can do something at the level of holding accountable the school when they overstep their bounds in their policy writing? So not even, New Jersey has a policy where you keep a separate file for every kid, just in case. They want something to not be told to the parents. It's not just on a case-by-case basis. They have an entire separate technological system set up for this, and it's mandatory. It's in the policy. And they've had lawyers in to explain. I watched a YouTube and the lawyer's like, well, this is the law and you have to do it. And the school officials are like, okay, well, I don't want to run afoul of this. What can't I tell the parents? No questioning. Nobody was sitting there in this little session webinar saying, I can't do this. This is unethical. This just feels wrong to me. They're like, all right, well, how do I follow the law? How is that okay?
It's not okay. People need to, yes, there's litigation, but you may or may not get funding for your litigation. You may or not be able to afford litigation. And you may have to, one thing you can do is go to school board meetings.
Now, do the school board meetings, I mean, I know that they are instrumental in drafting school district safety policies, but they can't tinker with compliance with title legislation. So Title IX comes in and tells them what they have to do. Bathroom policy.
We just described a case where California is completely ignoring the Civil Rights Act of 1954. I mean, you have to go and you have to pay attention. And and if you have kids in school, you need to see what they're coming home with.
Yeah.
And you need to talk to them. And
all right.
Not in a suspicious, creepy way, but you need to find out what's going in class.
Right. And then I guess it all comes down to, every time I get to the end of these, I always say, well, or you could leave, vote with your feet and leave. And that gets to my final question. I'm concerned about how the practice of law is adapting to things like algorithms and AI that are making decisions about people's access to a wide variety of things based on suspicions. So I'll give you an example. My husband runs a Facebook Marketplace little side thing where he sells some stuff, and it's all totally legal, whatever. But they shut it down. Facebook shut it. It's all connected for where people can send money. And, he signed all the papers and he looked in it. He read it. He said, they have to provide evidence before they can shut down his shop and keep his money and all this kind of stuff, or he wouldn't have done it. And one of their little bots said, this item, it was a battery charging thing. This item violates our policies on breast pumps. And he's like, it's not a breast pump. It's a battery. What? So he filled out all the complaint, and this was their answer. I'm not exaggerating. He even called someone on the phone, and this was their answer. Our algorithm detected suspicious activity with that post, so we shut down your account. He said, yeah, I got that. That came up in the pop-up. What are you going to do about it? You have like $50 of my money that somebody sent. I've already sent the item out. I want it back. I need my shop open back up so I can continue to do business. And I can sit here all day and say, don't do business on Facebook because this is what they're going to do. But it's where he has the greatest access to actually do the business. And they've just said, too bad, so sad. You have no recourse. NPS, we're keeping your money. Now, that's one tiny little example. But I'm seeing, we've heard stories of people shutting down PayPal accounts, bank accounts, seizing things on suspicions, and then nothing happens. Nothing happens. Like, you go to get help and they say, sorry, it's the algorithm. Sorry, it's the system. The AI told us to do it. You have no recourse. There's nothing you can do. And there's no lawyer for that. I mean, you could, but now you're spending lots of time, money, etc., to probably go nowhere. And I'm seeing this happen more and more, and I'm seeing it happen along political lines. In other words, you can't help but feel sometimes if things are just suddenly, because it just suddenly shut down. And he has similar views to mine, and he's very vocal on Facebook. You can't help but wonder.
Nothing to wonder about. It's exactly what it seems. All we have to do is just keep having conversations like this, hope that they don't get demonetized or taken down. And if they are, or in parallel, put them on places where they can be freely accessed, and just keep fighting the fight. It's not our obligation to win it. It's our obligation to fight it.
Yeah, I think that's really the end, is we're just going to have to build alternative systems to use.
Like homeschooling, which is what you were doing, what you do with your kids.
And I was doing it, 15 years ago. So, I got shut down. I was one of the early people to be told you're engaging in wrongthink. And she, in her little speech, I was told too that I was, not I was neglecting my children by not giving them access to the state effectively. And it was surreal, absolutely surreal. I just sat there listening, like, I'm not some, I'm not an uneducated person. I know I actually have a master's in education, and she's telling me. not only put my children into the school, but go get a job teaching, even though you haven't taught in over a decade. It was like, anyway, I am so grateful that you decided to accept my invitation and come here and talk to
My
us.
pleasure, of course, Deb.
It's
Always happy to
obviously
talk to you.
going to be an ongoing thing with the law. But I would probably say to my audience that you should, well, first of all, you should follow Ron, so you can keep abreast of things, because you do keep tabs on all this stuff. And the election, you can get really good information on what's going on with different elections around the country following Ron, because you're watching that very closely. But also, I think it would behoove people to find out who the attorneys are in your area who have sense any way you can, because you never know when that day is going to arrive.
There are a lot of nonprofits, a lot of foundations, a lot of public interest law firms that are providing. And I'll tell you something, in terms of discrimination, not so much or less so with the sexuality stuff, but in terms of discrimination, especially anti-Semitism, a lot of firms are looking for plaintiffs. We see what's going on the campuses, and astonishingly, there's a real reluctance on the part of Jewish students to rock the boat. Folks, you're going to get thrown off that boat.
Yeah. And you can't, I've heard from a few students who said, I don't want to be the victim, or I don't want to look like I'm crying victim. Like, but you are.
That's
I don't mean,
understandable. It's understandable.
It's understandable. And I understand that pride. I understand I want to stay below the radar. I understand all of that. But we have this opportunity now. They did not have it 90 years ago.
And if we don't make law on these cases, if we don't push back now, you will not get the opportunity to do it in the future.
That's right.
And you won't want to rock the boat. Like I said, you'll be off that boat. It's going to happen in your career, or perhaps in your child's, in your child's schooling, and you're the one who let it go.
That's right.
I'm not blaming you for being victimized, but if you are, but there are a lot of not just people like the Center for American Liberties is affiliated with my law firm, the Dhillon Law Group, but there are many other people, many other organizations looking for people to litigate these issues with free of charge.
Yeah. Thank you for sharing that. So that's all we have for you today. Thank you to everybody watching or listening. Please, again, like, share, and subscribe, and we'll see you next time.
Thanks, Deb.
Thank you.